So, the two sections that apply in relation to removing restrictive covenants or varying them are section 60 subsection 2 and section 60 subsection 5. Now look at the first one. Now this really applies to covenants that were created after June of 1991, and they don't come up that often because these covenants, remember, have been made back in the 20s and 30s. So if it does come up, that's the section you want to look at. I'm not going to read it out there for you, but do have a look at it, and you've got to remember, you've got to look at whether or not the land benefited by the restriction will be unlikely to suffer financial loss, loss of amenity, loss arising from change to the character of the neighbourhood, or any other material detriment. So they're the things you'll be looking at.
And the issue was not whether or not you could identify any possible detriment, a matter that we'll come to when we talk for the other subsection. It was whether or not an owner of land benefited by the restriction is unlikely to, and that extra elbow room in allowing a court to consider and balance the position of the beneficiaries is allowed for in the earlier subsection, which relates to the later covenants. A recent example of an application of that subsection was in Pappalardo and Knox City Council last year. What had happened there was a planning scheme that restricted building on a particular building envelope too close to a boundary to allow a feeling of spaciousness and amenity that would make the neighbourhood much more expensive seeming than it otherwise would have been. And the applicant there had wanted to put in a pool and a pool deck. So no structure as such, but the pool itself, and to the extent that there was a structure, it was only a cabana or a pool deck. The court thought it appropriate, the tribunal, I beg your pardon, thought it appropriate for a permit to issue under the planning scheme and put in a condition, again that weighed language. It was allowed with a condition, and in this particular case, the ability to exceed the building envelope restriction, more properly, was limited to that particular purpose of building the pool and the deck. And the tribunal member said, likewise, having decided that, you understand, that it could be accommodated, then said, I find it unlikely that any loss or detriment of the kind referred to in section 60, subsection 2, would result from the variation to the building envelope to reflect the as-constructed building. So you see the decision was made first. Effectively, we see that the covenant is there. Is it really going to be that much of a problem to have a pool deck? Will that breach the spirit of the covenant? No. Therefore, it's easy for the tribunal member to say, to the extent that there's a detriment that might arise out of the technical breach of that, I don't find that it's a sufficient detriment under section 60, subsection 2. Not as easy to do under section 60, subsection 5.
So, section 60, subsection 5 is the more stringent test, and this applies to the majority of covenants which were actually created prior to June of 1991. So this is the section that you'll be mostly looking at. Now this section provides that the council must not grant a permit which allows a removal or variation of a restriction unless it's satisfied of a few things. Firstly, the owner of any land benefited by the restriction will be unlikely to suffer any detriment of any kind. That includes perceived detriment, and we're talking about a case later on about that, as a consequence of the removal of the variation. Secondly, if that owner has objected to the grant of the permit, the objection is made, is vexatious or is not made in good faith. And we're also talking about how are applications to very restrictive covenants considered. Now, the cases which we'll be talking about mainly deal with those that were pre-1991. So section 60, subsection 2 hasn't really been a major issue, but please look at sections 60, subsection 5 and 61, subsection 4. They're the ones that you'll be mostly looking at in your cases. Now, if a responsible authority received an application to vary a registered restrictive covenant, any consideration of the application must be on the basis there will be no detriment caused by the decision to a benefiting owner, even if that benefiting owner did not object. Now, examples of variations that are permitted, for example, you've got a single dwelling house, which can now be, for example, 2 dwellings on that lot of land. You've got a brick veneer single-storey construction, and that ends up being varied, so it can be a double-storey construction. And those sorts of things occur under section 60, subsection 5 of the Act. That's how it actually becomes available.
And you already hear the elements of stringency coming into that iteration of the test. Satisfied that there's no detriment, and whether or not there is an objector before the tribunal. In other words, even if that benefiting owner doesn't object, it's still a consideration that has to be held. Special division of the tribunal, 5 members sitting, heard the case of Scuderi and Hume City Council in 1998 in an attempt to rationalise the test for applying this subsection. There were 2 appeals heard together. It concerned land in Greenvale. The owner sought to develop a lot and to build 6 dwellings. The council granted the permit, and an appeal against that decision was the subject of the first appeal before VCAT, because a decision to grant gives rise to an application pursuant to Section 82 of the Act if you're aggrieved by that. And it turned out that such a development would, once the permit was granted for it, would then be in breach of a restrictive covenant over the land that prevented the erection of more than one dwelling. So the owner accordingly had to seek to modify the covenant pursuant to Section 60, subsection 5. Council found for the objectors and then refused the modification, leaving the project in limbo. And so this was the subject of the second appeal before the tribunal, because the refusal to modify a covenant itself gives rise to a claim to making a claim to VCAT pursuant to Section 77 of the Act. And other grounds, by the way, include coming to VCAT because council hasn't made any decision within a set time, or because the conditions that it has imposed are unacceptable and you want to have a rehearing. Going to VCAT amounts to a rehearing procedure being invoked. So of what we're discussing now, it's the second appeal that concerns us today because we're talking about varying or removing restrictive covenants. The strongest argument in favour of the modification was that the retention of the restrictive covenant was said to serve no purpose, and it stifled the achievement of government policy in terms of urban consolidation. Familiar language? I hope so by now. This is the square collision between what I've described as the public planning and the private law squarely before the tribunal. So it served as a good test case, because what was being said was the people charged with the responsibility for proper amenity, sustainability, fair use had okayed this. It was consistent with their green lights. It was some codgers of generations past presuming to decide for the future what restrictions were going to be on building. The objectors made the usual objections on the usual grounds. They didn't think it was a matter of old codgers at all. They thought it was a matter of saying this is keeping the neighbourhood the way we want it to without some white shoe developers coming along and ruining everything. So not only is it public versus private, it's a kind of old versus new vibe at the same time. An analysis of the material that the objectors had put before the tribunal fell into what will, I'm sure for many of you, be familiar categories. What are the kinds of objections that are raised? Increase in traffic and noise, a very popular one. A reduction in safety, a decrease in value, the touchstone, I think, perhaps, that underlies all of this. That it would accordingly spoil street presentation, that it would be brought into an area where there were not already flats or medium density housing, that it would set a precedent, and here again is a disguised version of the public versus private. There goes the neighbourhood is the subtitle of this objection, and where a planning scheme or a planning authority had already allowed for that, population pressures in Melbourne being what they are, this is not a surprising situation. It was the neighbours saying, who had got in and were in their homes, effectively using this format to resist the increased population in their neighbourhood. Lack of car spaces, safety of trees that would have to be taken out, that they imputed a shabby profit motive to the applicant. This is the polite form, I think, of using my rude white shoe brigade developer line, and the limitation of open space. And you will see these cropping up again and again as being the bases. The tribunal quoted from the second reading speech that had introduced these sections, all of Section 60 into the Act, and it said the planning minister, the relevant planning minister giving the second reading speech, Mr McClellan, had said the effect of this clause is that permits should be granted only for dead wood covenants if no owner benefiting from the covenant objects to its removal or variation. The alternative avenue is to remove or vary a covenant remaining in place, being an application to the Supreme Court under the Property Law Act or the preparation of a planning scheme amendment. The other two alternatives we've been discussing this morning. Considering the authorities to date, the tribunal set out various guidelines. It's for the responsible authority, the council, or the tribunal to determine whether any covenant beneficiary will be unlikely to suffer detriment of any kind. They had to make their own decision about that. It had to be made on the evidence in the instant case, including the appeal site and its environs. That will come to be quite important as you see reams of VCAT members and Supreme Court judges with their train taking a majestic tour around the site in question. That, I suspect, turns out to be one of the most telling items of evidence in the whole project. The Good Design Guide for medium density housing that's been promulgated, compliance with that is a useful factor for an applicant to be able to tick off, but that itself doesn't establish the stringency of the test, that there is no detriment to be suffered. The wording is really as absolute as it sounds. Indeed, even in that regard, there has to be a real chance or possibility that a detriment will result. Mere assertion is insufficient, but in a way that's not saying very much because the real chance or possibility is not quantified. So the possibility, albeit real, because we're not making it up when we identify it, is sufficient to defeat the application. To make matters worse and to support the idea that it was to get rid of deadwood covenants, the subsection requires consideration of detriments of any kind. That can actually be aesthetic. It can, and I say actually be aesthetic. Aesthetic amenity is important, but as everyone would understand, it's a very movable feast in terms of what amounts to a breach of that. One person's eyesore is another person's great postmodern statement, sufficient for the decision maker to take that into account under this subsection. And the nature of the inquiry under this subsection, the court held, is fundamentally different from that appropriate in an ordinary permit appeal because the former is concerned with any detriment, whereas the latter, like the Good Design Guide, requires a balancing of advantages and detriments. The issue for the tribunal to determine is whether it's satisfied to the requisite standard that the variation of the restrictive covenant would not as a likelihood cause any detriment. We're saying that because I think it's our tendency as lawyers generally to in fact do a balancing exercise. Our approach, unless you do these every day, in which case probably you should be up here, is to actually look at pros and cons as though one could overcome an objector's, I've given you the litany of types of complaints by saying, yes, look, that's possible, but overall, this is what's required. It's that very approach that was stopped by this case and arguably by the wording of the subsection itself.
Now, the test in this Scuderi case was further amplified in 2002 by the VCAT decision of McFarlane and the Greater Dandenong City Council decision, and it underlined the stringency of the test, and its dicta have been consistently followed. Now, I'll go through the three main points out of this decision. It's for the tribunal alone to determine whether any covenant beneficiary will be unlikely to suffer any detriment of any kind if the variation is permitted. In other words, it's not a question of whether the tribunal is satisfied whether there will be a detriment. The tribunal must be positively satisfied there will be no detriment. Secondly, the mere assertion of an existence of a detriment is not sufficient to demonstrate its existence. Loss of amenity will constitute a detriment, and amenity includes an appeal to aesthetic judgment, as the other case mentioned as well, which is quite difficult to measure, as you can well appreciate. However, the notion of perceived detriment specifically contemplates that this consideration is relevant to the inquiry. And lastly, the determination must be made out on the evidence before the tribunal, including the appeal site and its environs.
Have we convinced you yet that this is a very, very stringent subsection? No? Well, there's another limb that needs to be satisfied in addition to the foregoing, and that is that any objections made by beneficiaries of the covenant that are not vexatious or made in bad faith are a death knell to the variation or removal application. It's a very, very difficult test to surmount. In other words, this wonderful drafting of everything in the negative, you must find that there is vexatious or an application not made in good faith in order to avoid the objector defeating the application process. The way it's been termed is that only a, quote, hopeless and unarguable case falls within this category. There are two ways in which this has been considered. One is the rat bag component, that's my name for it. I don't think anyone's been rude enough to put that in a published judgment, where you have almost a posse of people roped in by an objector with a bee in their bonnet. And even this, by the way, one person's rat bag is another person's freedom fighter, so we even have to be careful here. There have been circumstances where neighbours have been corralled effectively into putting their names to an objection. That sort of action in certain instances in the circumstances of the case, because it's not a clear-cut thing, can be an example of not acting in good faith. The one decision in, I suspect, the more frequent case was provided by the objectors in Consuranakis Town Planning Services and Hepburn Shire Council, a 2007 VCAT decision. Imagine how disconsolate the objectors must have felt when, having somehow through the ether heard what I've just said about how impossible it is to overcome that section for the applicant, found that they had achieved, in fact, this rare but dubious position. They, in fact, were the vexatious and not in good faith objectors. And how? Were they a bunch of people marching the streets with lit torches and pitchforks? No. Senior member Richard Horsfall, as the former Vice President, held, whilst an objection would be regarded as vexatious and not made in good faith if the proceedings were instituted to annoy or embarrass the person against whom they were brought, hinting at the kinds of situation I've just described to you, or brought for collateral purposes, that not quite explained, perhaps leaving it to the imagination of the litigator, they may also be properly regarded as vexatious if, irrespective of the motive of the litigant, they're groundless or having no merit. And as good lawyers as we all are, we see in that slight slit an avenue whereby we can elbow a little bit of space in overcoming this limb. That's because the senior member went on to say, I find no fault with the objector's intentions or motives. It's not that kind of case. His objection is made honestly, but I find it does not satisfy the test required in that it is groundless and has no merit. So despite the wording, one can see some room, some glimmer, where you have a beautiful proposed development, which really does nothing but actually lift the amenity and possibly the value of a neighbourhood. But you have nonetheless some stick-in-the-mud objectors. Maybe it's this case that gives you some hope in saying, whereas you would think it would be defeated under the normal wording, vexatious, not made in good faith, that's high-level language. Maybe this is the case where one can say, we're not calling anybody names, you don't have to cast any aspersions on the objector. It's just that they can't possibly win. And that, to me, is actually a way of depriving the second limb of a role in particular cases, but don't say you heard it from me.
Okay, the third method in removing or varying restrictive covenants is by an application to the Supreme Court. Now remember, we're using a different act, the Property Law Act, and it's section 84, subsection 1. So the relevant provisions really are subsections 1A, which has 2 limbs, and subsection 1C, which I'll talk to you about in the case of Rackus. Now, in the case of Rackus, it's an important Supreme Court decision which has provided really clear direction on the law in relation to the removal and variation of restrictive covenants under the Property Law Act. Here, the applicant tried to remove a single dwelling covenant and wanted to construct 2 dwellings. However, the applicant made a fatal error, and in his evidence, he didn't have any specific plans or proposals in relation to the property. And all he was really doing is trying to clarify what options were available to him. And the applicant agreed he was partially motivated by the potential to increase the value of the property by having a couple dwellings, which the courts didn't look at too favourably. And the court essentially warned that applicants should be specific as possible about the proposals in mind, so that the court could be in a really good position to assess the impact to those proposals that it may have on all parties concerned. So the plaintiff essentially failed to produce any specific plans, and the case went on to talk about, and it pointed out quite precisely how to apply these subsections of 1A and 1C. So the applicant has either the onus, this comes from the case, of establishing the matter set out in either limb of subsection 1A, or it can do so by doing section 84, subsection 1C, in order to have a remedy available, subject to the court's discretion, of course. So the first limb of 1A talks to you about due to changes in the character of the property or neighbourhood or other circumstances, the covenant is obsolete. Now the case went on to describe or define what obsolete actually meant. And a covenant is obsolete if it can no longer achieve or fulfil any of its original objects or purposes and has become futile or useless. So a covenant is not obsolete if it's still capable of fulfilling its original purpose, even if it's only to a diminished extent. So if a covenant continues to have any value for the persons entitled to the benefit, then rarely, if ever, it will be considered obsolete. So that's worth knowing as well. The second limb is the covenant's continued existence would impede the reasonable user for the land without practical benefit to the other persons. And subsection 1C, it requires a kind of a comparison between the benefits initially intended to be conferred and actually conferred by the covenant, and the benefits, if any, which will remain after the covenant has been discharged or modified. And so if the evidence shows the difference between the two will not be substantial, then the ground of subsection 1C is made out. So really thinking about will not substantially injure those entitled to the benefit of the restriction. That's the kind of concept which you should be looking at. So some other useful case law, and that all came from the case of Rackus of 2008. Other useful case law in relation to this section as well was Stanhill Proprietary Limited and Jackson. That was another Supreme Court decision of 2005. Now, Justice Morris in this case talked about the modification of a restriction so as to permit the erection of no more than 2 dwellings. He thought it wouldn't substantially injure persons entitled to the benefit of the restriction. It would be compatible to the existing development of the area. It would avoid the appearance of a multi-dwelling apartment, and there was enough land for use of landscaping and those sorts of things. And the level of activity, that being of 2 dwellings as opposed to 1, it was unlikely to be significantly different, and that included traffic considerations and activity as well. And the construction of 2 dwellings overall would enhance the use of the land. Now, the next question is the quarrying provision, to dig or not to dig. That's really the question. Well, maybe it was the question, because the case of Brissac Investments Proprietary Limited and Stonington went on to explain, I suppose, VCAT's kind of thought process as to what happens these days. So, the no quarrying covenant has shifted from a more traditional and literal interpretation to a more purposive interpretation. So the covenants were directed towards preventing the use of land for quarrying, compared to, for example, the need to have an underground car park, the need to have an in-ground pool. And it's all about what is considered part and parcel of the use of a development for a dwelling house. So it seems reasonable that you should have, or should be able to have a pool or an underground car park with a home, because it's kind of attached to it. It's kind of part and parcel. Now, that case of Stanhill, which I mentioned earlier, was also followed by the case of Hillman of 2008. And that case really talks about the fact that there was no substantial injury to the benefiting owners. And in this case, Disanayake, they were permitted to retain the second story, which they had built, because it wasn't really substantially injuring the benefiting owners. And that was changed from a one-story construction.
The Stanhill decision that we've referred to is really the locus classicus of this type of application. Part of the reason for that was I need to go back to my three-pronged structure of the public law, the private law, and the bridge provided by the courts over the top. Justice Morris had started his decision in the Stanhill case by noting that the tradition up to that time had been for restrictive covenants to be removed or modified with a great deal of difficulty. In that case, the issue was not so much town planning versus contractual, but the very, up to that time, but the very sacred nature of the contractual arrangement that had been made, and that given that this was a right that had effectively been allowed to future successors of the beneficiary land, it wasn't for the court, some years perhaps after the beneficiary, the successors, had bought their land, to come along and take away and, as it were, obliterate a right that they had happily been enjoying, that was sitting on the title to the property they'd bought for the world to know and take account of, and that they may arguably had factored into the value of their house. For a court to come along and say, oh, well, sorry about that, there's a developer here who actually wants to ignore all of that and start building flats, had been considered anathema by the courts. What Justice Morris said in Stanhill was not throwing that out of the window by any means. However, just as the council had now started bleeding into restrictive covenant considerations when it considered the future use that might be put to the application for a permit before it, so the court has now gone in the opposite direction from that sanctity of contract, and everyone knows what the interests in the land are, into a more policy consideration as to whether or not there would be any harm done. That's my gloss, by what was proposed, despite the fact, or whilst acknowledging the fact that parties had paid presumably valuable money for property that enjoyed this benefit. So what you then found was a court that was more unlikely to find that a covenant was obsolete. That's the nod to the fact that it's been there and everyone knows it's there. But in this second limb that Stephen has described, not subsection B, which is consent, but this detriment consideration, what you now found was the court now, not just VCAT, playing its part as a de facto policy, planning authority. The reason I've given you that long introduction to Stanhill before discussing other matters is because when you look at subsequent cases, we've given you the references for some that we've chosen that are worth your consideration when you have these kinds of matters. What you have is an application of the policy that I've just mentioned to you. Therefore, the cases, for the most part, are a careful recording of what are in fact subjective considerations confined to the land and the circumstances in the application before the judge. In Bevilacqua and Merrikovsky, for example, a 2005 decision, these are usually about medium density housing in the teeth of a restrictive covenant restricting more than one dwelling. You get a statement of relevant considerations. There's reliable evidence that the restriction is no longer necessary for any reasonable purpose by the parties who benefit, that the redevelopment would have very limited, if any, potential flow-on effect. That's the there goes the neighbourhood argument. That any fear that it might open the floodgates for similar successful applications, that's not the case here. The modification is deemed appropriate. That this property has a particular geographical location which distinguishes it from other lots in the subdivision. In this case and in various others, what I had alluded to before, the judge takes a stroll around the neighbourhood, and it's not a how long is the Chancellor's foot situation, but it may be, you know, what shape is the judge's slide rule. If they take the view that either it's not that much of a neighbourhood that needs protecting anyway, or that this is a marvellous development that will suit it down to the ground, I suspect that that picture is going to be worth 1,000 submissions and words. Having said that, there's no doubt about it, the court, if it's going to come out of its ivory tower and play this de facto quasi-public planning role, cutting across a covenant, as little as possible should be left to the imagination and fears of the court. Traffic engineering surveys with detailed analyses of what the expected traffic flow will be. Detailed engineering or architects' plans giving very clear depictions of what the development is expected to look like are going to make the difference, that and the walk around the neighbourhood, between the falling within Limb C and falling outside of Limb C. That's because I think no court is going to totally abandon the idea that these restrictive covenants exist for some touchy-feely vibe type argument as what's planned. In other words, the more information that you can give them, the better. Fraser and De Paulo, a 2008 decision of Justice Coghlan, falls into the same category. To ascertain what the neighbourhood was, the visit was made, and the character ascertained from the walk on the ground. The Nolan and Moreland case was the same. A plan had been lodged and a landscape plan showing even down to tree level what the final version was going to look like. I've mentioned the Zhang and Banyul City Council case, a decision of VCAT last year, because one must not forget the trees. The member had inspected, apparently gone out with its stethoscope, had gone out and inspected the health of the trees to assess whether they could be removed, contrary to a restrictive covenant in order to permit development. And the council wasn't allowed to, quote, hide behind this topic, which is really all for the trees, Your Worship, sort of approach, to object to an unfavourable development proposal. So trees are loved but not sufficient to bypass the considerations, the subjective considerations I've been speaking of. Parsons and Greater Bendigo City Council, which I've also mentioned, look, may not arise very often, but it was interesting because finally it was an example of where the public versus private collision was at least made explicit. In the Department of Sustainability and Environment had to deal with the Greater Bendigo National Park and had set out in its planning scheme, with negotiation between the forest people and the developers, an agreement that there would be a 30-metre buffer between the park and any development. The applicant had negotiated, or it had finally been whittled down to a 20-metre restriction. And this applicant, Parsons, had come up wanting a development that was within 10 metres. Now, you would think that all counters would be set at naught and there would be a stroll in the park and there'd be a picnic looking at the potential development to see whether it would be affected. In fact, not so. The court made the point that as recently as 2006, Council had gazetted the relevant 20-metre buffer into its planning scheme. It was recognising a need to address an urban forest or urban park interface, and that given that that was its policy, it was the 20-metre restriction that was there when the applicant had bought his lot, in this restriction that had very recently been created and negotiated, that the court actually said, or the tribunal actually said, no, we're going to allow the planners to have the say as to how this is done, and we're not going to give the nod to some general private law notion of just considering the position of the parties at this time.
Now, we've provided, we hope, a useful checklist to go through. So think of things like, do you need to engage an expert or a planner?
Yes.
Do you need specific plans or proposals? Go to the council first, obviously, for an application. If not, you'll go to VCAT when you're talking about the planning and environment sections. And think about also a required to give notice.
Costs is the magic question, maybe the first question that you'll be asked, so we're dealing with it last. You understand from what's followed that in seeking to vary or remove these restrictions, you're seeking effectively to take away a right, or if you're the objector, you're having a right taken away from you that you've hitherto enjoyed, even though costs are in the discretion of the court tribunal as always. The costs follow the event general pattern is interrupted by that consideration that I've just mentioned to you. Consequently, if the applicant achieves something less than what they've asked for, one of these compromise positions, the tribunal will tend to allow the defendant their costs. Also, the court will tend to allow the defendants their costs. In the case of Ree Withers, Justice Anderson said, though it is a matter of discretion, unless the objections taken are frivolous, an unsuccessful objector in a proper case should not have to bear the bitter burden of his own costs when all he has been doing is seeking to maintain the continuance of a privilege which by law is his. Oh, the humanity. If the applicant is wholly successful, even then, the usual order will be no order as to costs. So you bear that in mind when you factor the costings of the matter. Okay.
Now we're just going to touch on easements, how to remove and vary them, as I've got a couple of minutes to go. Now, essentially, an easement is a right enjoyed by one landowner over another to do something over the land. Okay, so essentially they run with the land, and it usually takes some overt legal action to remove that. So types of easements, obviously to convey something, water, gas pipes, things like that, drainage, sewerage, a right of way to go over someone else's property, or party wall easements. Now there's some important concepts. You've got the dominant tenement, who, that's the land that has the rights. So for example, it's the owner of the dominant land that has the right to go over the neighbour's land, and conversely, the servient tenement, they're the ones that allow the dominant tenement to actually, for example, have rights to use that area, to use it as a right of way, for example. Now, the trends, the parties to easements in most cases agreed to surrender them. However, easements are also abandoned and extinguished, and the registrar has power to remove them. So, how to remove I was going to say a restrictive covenant. How to remove an easement? You look at the relevant legislation, and here we're talking about the Transfer of Land Act of 1958, sections 73(1) and 73(3). Subsection 1 talks about where it's been abandoned or extinguished, and section 73, subsection 3 talks about it's got to be for at least 30 years if it's been abandoned. So there's three ways of going through that. You either execute a release agreement between the parties by consent, you either merge the dominant and servient property. So for example, you've got two adjoining parcels of land, one owner has that, and then you're able to remove the easement because it's no longer necessary. Or thirdly, where the purpose for the easement no longer applies or it exists. So for example, you've got access to a community well, the lady who had it has passed away, it's been over 75 years old, plus the well isn't fit for health purposes. So all those sorts of things. So it can be either extinguished or abandoned.
We apologise. For those of you who came wearing your My Passion is Easements t-shirts underneath your shirts today, really, as you see, we've devoted virtually all the time to restrictive covenants because I think it's that tripartite forum that you've got to balance and the considerations that apply. Stephen will be very happy to come back on any morning that you choose, probably at 6 a.m, in fact, to discuss common law with respect to easements. We have allowed for some time for questions, but consistently with our adjustment into our multiple presentation, where all we needed was the coffee mug and the armchairs. We'd also be interested to hear not only if anyone has questions, but to what extent, in fact, you are seeing these matters, whether it's for architects asking help in clearing plans or having the carriage of applications. Do you see objectors? Is anyone seeing that the policy move into medium density housing has in fact hit home and is affecting you? So feel free not only to ask us if you wish to, but just to tell us if in fact you're seeing these kinds of matters from time to time.
I think, ladies and gentlemen, we're going to have to bring the session to an end, but if anyone has any questions that they want to ask Rena and Stephen after, I'm sure that they'll be able to stick around for a few minutes. Yes. Ladies and gentlemen, I'm sure that you'll agree with me that Rena and Stephen have presented a superb illustration of the principles that apply in this area of the law. They have reduced them to very simple propositions, and they have made some excellent practical suggestions about how to go about removing restrictive covenants and easements. Would you please join me in thanking them warmly for their superb